Okay, let's start now. Hello, everyone. And look, thank you all so much for coming. It's great to see you in real life. For the last few years, we've done our immigration updates as webinars, but we thought it was about time to do one in real life again, as we always used to do in the past. We will keep doing webinars in future because they're convenient for everyone, but I think we're going to mix it up. So we'll do some webinars, some in person. I have to do the housekeeping stuff, and the first thing is that there is no fire drill planned today. But if it does go off, the exit is just right there, right at the back of the room. The loser over there. The event is being recorded, so please just bear that in mind during the Q&A session, and we will send out the recording and slides after the event. So I'm Kim. I'm here with Emma, Vandana, and Robert. We have a lot of immigration changes to tell you about this. I'm sure you know there's big policy changes. So the government is restricting skilled migration. There's more enforcement. Work visas are becoming even more expensive than they are already. And there is the plan for earned settlement. That's the plan to increase the qualifying period for indefinite leave to remain from 5 years to 10 years. Often at our webinars and events, we often have someone from the Home Office joining us, which can be very good. We don't today. One good thing about that is that we don't have to be polite about all the changes. So we will explain them all, but we'll also give our own take on these. And I'm very keen as well to hear what you think about these changes. So we will ask that, especially towards the end of the session. It'd be great to hear your views on this. Most of what we're talking about today comes from the Immigration White Paper, which was published in May. And that was just a few days, actually, if you remember, just a few days before our last webinar. The stated aims of the White Paper were to restore order, control, and fairness to the immigration system, to bring down net migration, and to promote economic growth. So those are the stated aims. There's lots of order and control. The fairness is certainly a matter of opinion. Net migration has already come down, and I think it will come down further, partly as a result of what's being done at the moment. Obviously, the economic growth is not looking so good. That's a whole different story. I think there's also a very obvious unstated political aim in the white paper, and that is to win back votes from Reform UK. It's very obvious that that's part of it. The white paper came out just after local elections in May, in which Reform did very well and Labour did very badly. And the white paper was accompanied by very aggressive anti-immigration rhetoric. Keir Starmer said at the press conference, he said, this strategy will finally take back control of our borders. So very consciously using the vote leave slogan, the Brexit vote leave slogan. And he said, we risk becoming an island of strangers, which was very controversial. And he since said he regretted saying that. But even the white paper itself, the foreword, said inward migration has exploded to over 1 million people a year, exploded. And the damage this has done to our country is incalculable. So it's extremely emotive language. And it's very obviously right-wing language. That's very clear. Personally, I think it's doubtful that what the Home Office is doing on legal migration is going to win back votes from Reform. My impression is that the small boats issue is much bigger for those people. Obviously, there's a question about what's the Labour government doing at all trying to do this sort of thing. The point is they are doing this. So there are restrictions. Lots of new restrictions, which we'll talk about. There are a few positive changes mixed in with all of this, so we'll cover those as well. So first of all, Emma's going to start off talking about skilled worker visas. Oh, sorry, we have no clickers. This is our giant clicker, which one, if it works. So Emma's going to talk about skilled worker visas. I'll give a recap on what's already happened since the white paper came out. Vandana, you're going to talk about what's still to come, because there are still some changes to come on skilled worker visas. Robert's going to mop up and talk about all kinds of stuff, other things that are important. And then I'm going to talk about earned settlement, that plan to increase the qualifying period for indefinite leave to remain. I'm going to ask for a bit of audience participation on that as well. So over to you, Emma. And you would like a microphone as well.
So, hi everyone. As Kim mentioned, I'm going to talk about the changes already in place for skilled worker visa, and I'm going to focus on the two main ones. Great, it's working. So the first one is the increase of the minimum skill level. As most of you know, this has increased from RQF3 to RQF6. RQF6 level being highly skilled, so it's more or less a bachelor degree role, and it's a situation which was in place before Brexit. Except now we don't have the EU workforce to undertake the lower skill role. So who does that apply to? It applies to your new skilled worker visa applicant sponsored from the 22nd of July this year. So the first time they were granted the skilled worker visa. So that does not apply anyone else with a skilled worker visa in place under the rules before the 22nd of July, if they have held a skilled worker visa permission since that date. There is an exemption where you can still sponsor the new individuals for jobs below RQF6 level if the occupation is on the temporary shortage list. So that exemption comes with restriction, unfortunately. So the individual, for example, cannot bring family member as dependent with them in the UK, as there are some exemption for children in very limited situation. More condition will be attached to this list. We have heard, for example, that maybe the individual will not be eligible for ILR if they are sponsored under this list. So an exemption, but with a lot of restriction. We have put some example of occupation code on the temporary shortage list. We have seen data analysis being used quite a lot. Business self-executive is always quite popular, or advertising and marketing associate as well. So what does that mean for, for most of the jobs that were on the list before? So we have put example of occupation code below RQF6, which are not on the temporary shortage list. So more than 100 occupations have been removed from the list, so you can't sponsor new applicant for those occupations. We have seen the hospitality being hit quite hard, and I believe, Kim, some of your clients have been affected by that?
Yes, absolutely. I mean, hospitality has been hit really hard, and especially no chefs. You can't sponsor a chef now if they're coming from outside the UK. It's really, really hard to find chefs. What you can still do, as Emma mentioned, it doesn't apply to people who were first sponsored before the July changes. So there's a sort of pool of people who can rotate around, and you can poach people who are already here, but otherwise you're stuck. And that's a real problem for hospitality. The government knows this. People have been talking about it a lot, but they've done it.
Thank you. And we also put some more example just to show you it's not just hospitality, it's any sectors, and it's also not just junior position, it's also managerial position. So quite a big change here. The second main change, sorry, oh gosh, it's too slow for me, is the minimum salary requirement increasing. As you may know, you have two thresholds for the general for the salary requirement. You have the general salary threshold, which has drastically increased on the 4th of April 2024, from £26,200 gross per year to £38,700. But it was not enough for the Home Office, so they did a second increase this year on the 22nd of July, and now it's 41,700 gross per year. So like more than 50K increase in a year and a half, not even. You have a reduced rate for new entrants, which are people who are switching from student or graduate visa, or people under the age of 26. When you sponsor them, the general salary threshold is 33,400 gross per year. So this does not apply to skilled worker visa holder, where they got their first skilled worker visa before under the rules before the 4th of April 2024. For them, the general salary threshold is 31,300 gross per year, and for new entrant, it's 25,000 gross per year. But in addition to this threshold, you also have to meet the going rate because it was not enough. So again, big increase on the 4th of April 2024, and again on the 22nd of July this year. And the going rate, as you must know, varies depending on the role. To give you an example, if you want to sponsor an engineer or maybe a software developer, you're more looking for a full-time week at 50 or 60K. So it's even higher than the general salary threshold. Again, lower going rate for skilled worker visa holder when the first visa was granted under the rule in place before the 4th of April 2024. Lot of salary to remember, sorry about the numbers. So what does that mean in practice? In practice, that means that you have complicated transitional provisions. So we have tried to summarize the situation here. You have three scenarios, really. The first one is if you have someone already in the UK on a skilled worker visa, and their skilled worker, the first skilled worker visa was granted under the rule in place before the 4th of April 2024, and they have held skilled worker visa permissions. It doesn't have to be the same skilled worker visa. They can have several of those continuously since that date. It's basically the best case scenario. It's bingo. You can benefit from the minimum salary threshold and also from the lower minimum skill level. That's a great situation to be in. Then you have the middle scenario, the second scenario, where you have someone already in the UK on a skilled worker visa, but this time the first skilled worker visa was granted under the rule from the 4th of April 2024 up to the 21st of July this year. So for those individuals, it's not as good. You have to pay the higher salary threshold, but you benefit from the lower minimum skill level. And then, unfortunately, you have your worst case scenario, someone who is not in the UK or who is in the UK but not on a skilled worker visa, or the skilled worker visa was granted under the rule from the 22nd of July this year. Then in this situation, you have to meet the higher minimum salary threshold and the higher skill level as well. So it's a lot of information. It's not easy to find. You will need to look at the tables in the immigration rules appending skill occupation. But obviously, we are here to help you, so please come to us and we can do the assessment and ensure that, depending on the individual circumstances, the right levels are met. And then just to wrap up, I just wanted to mention what we have seen around the sponsored. Yeah, I mean, this is. Sorry about that. Okay. Okay, great. So what we have seen in terms of practice, so we have seen tougher processes and more enforcement action. So for example, when we request certificate of sponsorship or define costs, we have seen the Home Office coming back to us and asking additional information, not all the time, but in more cases than usual. And they check, for example, if you, the sponsor, have changed ownership since your license was granted. So they really do a very scrutinize this. Then you have more sponsor license compliance checks and revocation, so less suspension. They go right away for revocation when they can. And also when you notify that someone has stopped working for you, normally the visa cancellation notice were sent within 6 months to the individual, sometimes years when it was COVID, but now it's taking 3 months more or less, so way quicker. And lastly, we wanted to share with you that the Home Office is now checking entry and exit data that they are getting from the airline when processing visa and ILR applications. And also interestingly, they are sharing this data with other organizations, and notably HMRC. And we have seen media reports saying that some child benefit payments were wrongly suspended because the Home Office travel record failed to show that the individual came back to the UK. So the HMRC thought that the person left the UK and was living abroad, so they were not entitled to child benefits, when actually it's just someone going on holiday and coming back. So it's quite interesting. It reminds us maybe a little bit of the Windrush scandal, because it was also basically data being wrongly recorded or not recorded at all. So it begs the question, are they going to learn from their mistake? So I'm going to hand over. Oh, sorry. Sorry, I just wanted to do the handover, but I'm going to hand over to my colleague Vandana, who's going to talk about the interesting bits, the changes still to come.
Before you do that.
Oh, yeah.
Just one thing on that. I mean, it really is very much like what happened with Windrush, where the Home Office couldn't, so they matched data with DWP, HMRC. They thought, oh, these people don't have the right to live here. So they immediately sent out letters saying, we don't think you've got the right to be here, so you've got 14 days to leave the UK. Instead of saying, look, we can't work out your status, can you help us, please? Same thing here, just saying, we're cutting your child benefit. You think, well, why didn't they go first and say, look, it appears to us you've left the UK, can you please help us out here. Have you, haven't you? Just went straight for that. They've stopped doing that, apparently. They've actually paused it. But I just think it's incredible that you just go straight for that based on just thinking, oh, well, we think it's right. And apparently there's a huge percentage where it's wrong. It's not like 1%. It's much, much higher. It's a huge number of people. So yeah, it's incredible. Anyway, sorry, Vandana, over to you.
Testing. Yeah. Great. So Emma's spoken about the changes which have already taken place, and that brings me nearly on to the changes which are still to come. So one of the more imminent changes is to the immigration skills charge. This is a charge that's payable by the sponsor at the point of assigning a certificate of sponsorship, and it's also one of the charges that cannot under any circumstances be passed on to sponsored workers. The change is that the immigration skills charge will increase by 32%, and it will apply to any cause which is assigned on or after the 16th of December 2025. What it means is that a large sponsor can expect to pay an extra £320 per year of sponsorship, and a small sponsor can expect to pay an extra £116 per year of sponsorship. So if you've got any sponsored workers who are coming up for an extension, or workers who you would need to switch into the skilled worker route, then it is worthwhile getting their causes assigned before the 16th of December, if possible. Now, once a cause is assigned, it needs to be used in an application within 3 months, and it is possible to submit a visa application up to 3 months before an intended work start date. So if you're looking at extensions, we usually set the start date, the new start date, as the day after the current visa expiry. And whilst this can be brought forward, you do need to be a bit careful around this so as not to leave the worker short of the required period for ILR, which is currently 5 years. But certainly, if you do have any workers who are coming up for an extension between now and, say, March 2026, then it's worthwhile getting their causes assigned before the increase, if possible. Now, for applications which are made from inside the UK, to assign a cause, you need a cause allocation. If you don't have any allocations, or you don't have enough allocations for the amount that you want to assign, you will need to request for an increase in allocations and use the priority service for that increase. The priority service, many of you already know, is heavily oversubscribed. It's very difficult to secure, and it generally comes down to luck. It does get progressively worse as the changes we get closer to the changes. So definitely worthwhile checking your allocations now and applying for an increase as soon as possible if needed. For applications which are made from outside the UK, we need a defined cause, a D cause, and that doesn't come from the allocations. It's requested on a case-by-case basis. It usually takes around 1 to 2 working days to be approved, but still worthwhile, checking if you've got any out-of-country applications and getting them assigned before the deadline as well. Okay, moving on to changes in the area of English language. So the English language requirement is going to get tougher for new skilled worker applicants. Currently, if an applicant isn't from a majority English-speaking country or doesn't have a degree that was taught in English, they need to sit an English language test. The required skill level for skilled workers is level B1, which is an intermediate level. But for applications which are submitted on or after the 8th of January 2026, the skill level will increase to level B2, which is an upper intermediate level. The main difference between B1 and B2 is that B1 users can handle everyday, familiar situations, whereas a B2 user should be able to handle more complex situations and make more confident and independent use of the language. So it may well be that some candidates might struggle with the B2 requirements. There is talks of scrapping the current system of allowing people to rely on degrees taught in English, because it's thought that those individuals still seem to have poor level of English. So they may well scrap that and actually make individuals sit English language tests. And we may also see them reduce the number of providers available for the test as well. But one thing I do want to make clear is that the new requirements for skilled worker applicants only applies to new skilled worker applicants. So for anyone who's already on the skilled worker route, they won't need to meet the high level for example, for an extension. The requirements are also going to be introduced for dependents. So for the first time ever, dependents of skilled workers will need to meet an English language requirement. The Home Office are planning to align the rules with that of partners of British citizens. So for an initial application, a dependent will need to meet level A1, which is a very basic level. And then to apply for an extension, then they'll need to meet level A2 and then level B1 for indefinitely to remain. Now, the white paper didn't actually mention what components will be tested, but if they are planning to align the rules with that of partners of British citizens, then we can probably expect the test to be in speaking and listening only, rather than all 4 components that a skilled worker would be required to meet. But A1 is extremely basic, at least for the initial application, so hopefully not too much of an impact. But again, the details haven't yet been announced, and an implementation hasn't yet been set as well, so we need to be watching the space on that. So Emma mentioned briefly the interim temporary shortage list. This is a list for roles with a skills requirement between RQF level 3 and 5, which have fallen off the main list, but which the Migration Advisory Committee, the MAC committee, had identified is still in shortage or is crucial to the delivery of the UK's industrial strategy. The temporary shortage list sits alongside the immigration salary list, which a lot of you will remember is the former shortage occupation list. Both of these lists are due to stay in place until the 31st of December 2026. And then after that, the current immigration salary list will be abolished. And as for what will happen to the temporary shortage list, well, the government have asked the Migration Advisory Committee to conduct a review and advise on what the makeup should be. The MAC released their stage 1 report in October, and within that, they identified around 82 occupations to potentially stay on the list. The final list may well have less. The stage 2 review will run until July 2026, and there is a call for evidence, and that is to fine-tune the list that was identified in stage 1 and also to set out the qualifying criteria. But what's clear is that in order for a job to stay on the list, there needs to be what is called a workforce strategy or a jobs plan that's centered around training, and the aim of that is to maximize the use of the UK workforce. It's also worthwhile mentioning here that during the stage 1 review, the MAC did consider whether or not the old resident labour market test, the RLMT test, which some of you may remember, whether or not that should play a part in the temporary shortage list criteria, but they weren't quite able to come to an agreement on this, so we may well see it make a comeback. Moving on to changes in the area of sponsor compliance. So the Home Office will be increasingly checking HMRC PAY data to check that sponsored workers are actually being paid the amount that is specified on the COS. If they find that information isn't accurate, then that could lead to a compliance audit. So some things to bear in mind is in relation to cost arrangements. So if you have got an arrangement where you as a sponsor will be paying for immigration costs up front, and then you'll be asking a sponsored worker to repay some immigration costs or allowable costs like the visa application fee or the IHS fee, and they're going to be repaying it through salary deductions, that's something that needs to be factored into the salary calculation and also reflected on the COS. If a worker isn't going to be on UK payroll, for example, because it's going to remain on the overseas payroll, that's fine, but again, something that needs to be reflected on the COS. Gone are the days where we need to report salary increases, but we do still need to report salary reductions. So, for example, if someone goes on maternity or unpaid leave, that needs to be reflected on the COS. The last thing that you want is the Home Office checking HMRC data, reviewing the COS and the reports, and actually not really fully understanding or being confident that the individual is being paid what they should be paid. It's very important to be monitoring that. Slide. No? Okay. What isn't changing or isn't changing yet? Well, the Home Office have been beta or better testing a new upgraded sponsor management system. But they have since abandoned that transformation because their assessments indicated that actually it could lead to a poorer, or some would say even poorer, sponsorship management service than that which is currently in place. So sadly for us, no new SMS system. We've got to stick to the old clunky one. But yeah, in terms of training, the white paper did make quite heavy references to training. The government considered that economic migration shot up whilst training of domestic workforce has fallen. And to tackle this, they said that the immigration system needs to be linked to skills and training requirements so that no industry is able to rely solely on immigration to meet skills shortages. Now, I did mention earlier that the temporary shortage list will have a workforce strategy feature that focuses on training, but the question remains as to whether or not whether or not the government will in future go further and require sponsors more broadly to invest in training and workforce development. And then finally, in relation to refugee employment, the government planned to look at new reforms to allow a limited pool of refugees and displaced people to rely upon the sponsorship route, but we haven't really heard anything further on this. And now I will hand over to Robert.
So I hope we'll have some positive news. 'Cause you might have noticed that we haven't had any positive changes at all
Okay.
so far.
Let
But
me
you've
crawl
got a
around
couple,
for
haven't you?
positive. Yeah, there is potentially something positive here. If the slides move, yes. Okay, so as Kim mentioned, I'm going to sort of do a mop-up exercise, a roundup of all the other miscellaneous other changes that have happened. And one of the maybe arguably positive things that have happened is e-visas, their introduction is continuing. So as you probably remember, we had BRPs before, those credit card sized documents. Well, they've been gone for most people for some time, but people were still getting visa stickers in their passports. So they had sort of 90 days in which they had to enter the UK. For skilled workers, the visa stickers were gone or removed in July, and they were instructed to create UKVI accounts and access their e-visas. And for dependents of skilled workers and other sponsored categories, that happened on the 30th of October. So they got rid of visa stickers for those guys as well, and a few other categories. So there's still quite a few immigration categories about where you still get visa stickers in your passport. But only yesterday, after we'd finalized our slides, the government announced that they would provide a timeline for when they're going to roll it out further. So the sort of removal of visa stickers. And in that yesterday, the press release, it said that sometime next year, even visitors will be getting e-visas. So we can expect visas to go completely. And really the upside of this is that you don't have to hand in your passport when you're having your application process. So you can travel. So that's an added flexibility. You still have to go to a centre and have your biometrics, so give your fingerprints and have your photograph taken. But probably that will go at some point as well, but we don't really know. And the upside, so you can travel whilst your application is pending. And we often had clients who travel a lot who had no space in their passport for a visa sticker, and they'd have to go off and apply for a new passport before they can apply. Anyway, so that's done. We don't have to worry about that anymore, thankfully.
Robert, just one thing though,
Yeah.
because if you apply in the UK, you can't travel, even though you'll get your passport back, which is crazy. And we've asked the Home Office to change that, but no. So so people
That was
applying
a key
outside the
detail
UK, it's a
I
great
omitted.
change.
Thank you.
Yeah, but just make sure you
yeah,
can't travel
yeah.
if you've applied within the UK.
That's
You've got to
right.
wait for the decision.
That's it. That's right. So we're talking about people applying overseas. So they're the ones getting the visas stuck in their passports, or were. Right. There is an annoying feature or functionality problem with the system in that you can't generate a right to rent or a right to work share code, like evidence your permission before your visa has started, before the start date on your visa. So people, for example, you have an employee coming to the UK and they might want to visit and set up before their job starts and before their visa has started, maybe they're US nationals, for example. And those guys are finding that they can't evidence to landlords their right to rent, and that's causing a great deal of difficulty. So that's just something to bear in mind. Obviously, visitors from some nationalities, they do have a right to rent. They can evidence that using their passports, but some, nevertheless, we're seeing that landlords, they're not very forgiving, generally, landlords, unfortunately, and they can be quite difficult. The next slide is about graduates. So we have a graduate visa for those who finish university in the UK. So there was chat that we would get rid of this, that the government would abolish the graduate visa category, but that hasn't happened, thankfully. It's still there, but there's a plan now to reduce the duration that people who finish degrees get. So instead of getting 2 years, they're going to get 18 months. But that only happens from the 1st of January 2027, so a while away. If you get awarded a PhD in the UK, you can still get 3 years permission under the graduate visa category. We also have the high potential individual visa. So that's for people who graduate from very prestigious universities, not in the UK, so like Yale, Stanford, and so on. And if you graduated from one of these very prestigious universities in the last 5 years, you can get a visa to come to the UK for 2 years, and you get a free hand, really. You can do quite a lot. You can work, you can be self-employed, so it's very generous. The time you spend on that category doesn't count towards indefinite leave to remain, but still, it's an option for some people. And the government has doubled the number of universities that are on that list. So it's very focused on Western universities, but there are some Chinese universities on there as well. The next slide is global talent. Okay, so when government ministers talk about we want to attract the best and the brightest, really what they're talking about is the global talent category. We want people to apply under the global talent category. And there's been a very or relatively minor amendment for architects from yesterday. If you were part of a group achievement as an architect, you could potentially rely on that to help you get a global talent visa. So it's not just you individually, but you're part of a team or a group that did something successfully, then you might be able to get yourself endorsement using that. Also, the prestigious prizes list was expanded and added to. So if you get the Nobel Prize for Literature, you can get a global talent visa. But also there's other prizes that are less well known, like mathematical competitions or computing competitions. If you win an award in those fields, you have to have a look. Maybe it's on the list of approved prizes, and you might be able to get yourself a global talent visa on the back of that. There's probably more to come with this category. The government has talked about wanting to attract AI specialists and other hot sectors, and probably the changes that they might introduce to capture those sorts of people might well happen under the global talent category. So more to come, probably. The next bit is about right to work checks. Okay, so I'm sure all of you are very painfully familiar with right to work checks. So you're sort of checking people's documentation to make sure that they do indeed have immigration permission to be in the UK, that they have a right to work, so that you have your statutory excuse against any civil penalty if they were found to be working illegally. And when this was introduced a long time ago, in 1997, it was very much focused on employer-employee relationships. So it didn't care for self-employed people. There weren't so many, perhaps back then in 1997. But obviously the economy's moved a bit, and we've always had employers that will, less reputable employers that will say that their staff are self-employed when they're not, to get around things like tax and employment rights. And there's always been provision, or there has been for some time, provision in UKVI's guidance to look beyond how the relationship's described and look at the factual circumstances, say, oh no, actually this person is an employee and you should have done a right to work check. But there's a proposal at the moment to extend right to work checks for gig economy workers, so to people who are more likely to be self-employed, so delivery drivers, construction workers, and so on. So the gig economy will probably, so organizations working with those sorts of people will potentially need to be doing right to work checks, checking their immigration permission. So this is only a consultation that's ongoing at the moment, and it finishes in December. But this looks pretty nailed on. This looks like very likely to happen.
Yeah, and what we don't know is exactly how it's going to work. So because if it would apply to any contractors that you have, that would be huge. But as my reading of the bill is that it's very much, it's applying, you're going to have to check people who are, not people who are providing a service to you as an employer, but people who are providing a service on your behalf to your customers. So it seems to be framed that way, but we need to see exactly how it does pan out in the end. So we need to watch this.
Yeah. And another thing that perhaps is less nailed on, but maybe more likely, is digital ID cards. So, or ID. So it seems that every government at some point wants to introduce national ID cards. And obviously this government is no exception, and it's talking about digital ID cards for everyone. So British nationals, everyone in the UK. And it seems that this time might be different. It might actually happen because of digitalization, processes, and technology. It doesn't seem that will be that hard to do this. And also the government's already given some more details about it won't be charging for this. It will be issuing them for free. One of the centerpieces in the government statement about the proposal to introduce digital ID cards is that it would help fight illegal working. So that's not clear at all. I don't quite know how it would be an effective way to fight illegal working, but it could help with doing right to work checks for British nationals. So at the moment we have the digital identity service providers, which hasn't really taken off. So for British and Irish nationals, you can do online checks for them if you work with one of those providers, but you have to pay the provider, you have to have a contract with them, and it's really a fiddle. So most employers, as I guess is true for you guys in the room, is that you're checking physical documents, I'm going to guess passports and things like that. But if we move to a digital ID scheme, which included British nationals, perhaps it would be quite easy for everyone to sort of evidence their permission through an app on their phone as a quicker and more effective way to do it. And if it worked like that, maybe what we would have is a lot more checks on people's immigration permission, like the delivery driver who comes in to collect his order. They scan his face and they scan his digital ID and go, oh yes, you're that guy, and then give him the order. Maybe if we move to a system like that, perhaps it would be an effective way to combat illegal working, but without some sort of dramatic change in processes and how it works. I just can't see it.
Yeah, and also it's very controversial for all kinds of other reasons
Yeah.
as well. So who knows?
Yeah, the civil liberties point and so on. Right, I'll frisbee that back at you.
Oh, thank you. Okay. Earned settlement. So look, this is the proposal to increase the standard qualifying period for indefinite leave to remain from 5 years to 10 years. So why is the government doing this? Just to put it in the context, this was not in the Labour Party's manifesto last year. There was nothing about it at all. They talked about wanting to reduce net migration. There was no mention of this. To be fair, there was not much in the Labour Party manifesto at all about anything, but this was definitely not there. So where does it come from? I think that the key moment was a report by a think tank, the Centre for Policy Studies. They put out a report in February called Here to Stay, when they said that the wave of migration that had happened after Brexit, the Boris wave of millions of people coming on skilled worker visas, a lot of them, those people are in low-paid jobs, many of them care workers, and that when they're on track to get indefinite leave to remain. And when they get indefinite leave to remain, they will be able to claim welfare benefits. And the idea is this could cost the country more than £200 billion, and the country can't afford that. That was what they said. It's very controversial. Some people say that it's the opposite of the truth. Some people have said, actually, there's a net fiscal benefit to having these migrants. But it touched a nerve. And at the same time, around the same month, the Conservatives put out a statement saying that they would increase the qualifying period for indefinite leave to remain from 5 years to 10 years. And at the time, I remember seeing that thinking, this is, wow, you know, this shows how far the Conservatives have moved. But then Labour have proposed the same thing. So what's the plan? So as I'm sure you know, most visas which lead to indefinite leave to remain have a 5-year qualifying period. Not all, but most of them have a 5-year period. And the plan is to increase the default, the standard, to 10 years. It won't apply to family members of British citizens. That's been very clear. That's stated in the white paper. And it definitely won't apply to EU citizens granted permission under the settled status under the EU settlement scheme. That's for sure. And they can't do that because that's in the UK-EU withdrawal agreement. They'd be breaching an international treaty. Maybe Reform would do that. Labour's not going to do that. It's not clear if it will apply to existing visa holders who are on a 5-year route. And I'll come back to that. But that's one of the things that the white paper is silent about that. It doesn't say we will do this, we won't. It just doesn't say. Now, the white paper does say that some people will be able to qualify early, before 10 years, based on what they call points-based contributions to the UK economy and society. That was all there was in the white paper. There's also a concept called earned citizenship, and that's a similar idea. So the idea is, well, you know, you have to earn your early settlement, early indefinite leave to remain. At the moment, the sort of standard pattern is you work for 5 years, say you're on a skilled worker visa, you get your indefinite leave to remain after 5 years, you wait another year, you can apply for naturalization. The white paper says, well, look, why should you be able to do it so quickly? You should have to earn that as well. I don't know how that would work. If they're going to increase indefinite leave to remain to 10 years, how much longer will it take to get citizenship? That's been very quiet since then. It was mentioned in the white paper. No mention since then. So I think we can leave that one. The main attention is on earned settlement, so indefinite leave to remain. So not much in the white paper. There was a press release at the end of September when the Home Office said that a person, they can earn a reduction in the year, so get indefinite leave to remain earlier than 10 years if they meet earnings or integration requirements. So earnings or integration requirements. And some people won't get it at all if they break the rules. So, and then they list out certain criteria. So these are the proposed conditions: being in work, making a certain level of national insurance contributions, not claiming welfare benefits, learning English to a high standard, having a spotless criminal record, and giving back, for example, working in your local community. So those are the conditions, the proposed conditions for ILR, indefinite leave to remain. That raises lots of questions. That's all we've got at the moment. That's all we got. So how's it going to work? To get early indefinite leave to remain, would you have to meet all of those conditions, or is there going to be some kind of tradable point system? They talk about a points-based system. It's a bit like digital IDs. Every government talks about points-based system, and they present what they're doing as a points-based system. It's an obsession. But and usually it doesn't really turn out to be a points-based system at all. But in this case, will it be the case that say for instance, you've got a couple, one on a skilled worker visa and a dependent. The dependent is not working. Maybe they've got young children. They're not working. They're not making national insurance contributions. Will they be able to get early indefinite leave to remain by, I don't know, doing voluntary work? What's the plan? We just don't know. A certain level of national insurance contributions. Clearly, we need to know what is that level. That's critical. Is it having a sort of full record throughout the year? You know, sort of the complete year for 5 years, or is it actual related to earnings? Perhaps it is. Welfare benefits. Well, most people on time-limited visas can't claim welfare benefits anyway at the moment, so it's not really an issue. Certainly, a skilled worker visa, you can't claim benefits, so you'll meet that one. English language, there's already English language requirements, as Vandana has explained, and that's changing. Criminal record, there are already pretty tight restrictions on criminality for indefinite leave to remain. So what's new here? Is this just talk? Is it just to sound tough? It's really hard to know. Giving back, you know, working in your local community, what does that mean? You know, it could sound good. You know, it's great for people to do community work, voluntary work, but unless it's clear, you can imagine it becoming some kind of bureaucratic box ticking thing. Is it really going to be something that's effective? I think the key thing is how high the bar is going to be set. So is the plan that pretty much all skilled worker visa holders who've been working, they get to the end of the 5 years and they will qualify? Is that the idea? Or is the idea to stop lower paid skilled worker visas, skilled worker visa holders getting indefinite leave to remain? We just don't know, you know, how is this, or maybe they're targeting other people. So perhaps refugees, if you're recognized as a refugee, you can claim benefits. So it's one of the rare time limited visas where you can. So is the idea to stop them? And we just don't know. And the key thing is about whether or not the rules will apply to existing visa holders. So we've had more questions about this than I think anything else since the white paper came out. We just don't know. At first, we thought surely not, because almost always there are transitional provisions for people who are already on a visa. You know, like Emma was talking about for skill level, salary level. So just thought surely they're not going to make this retrospective. And it would seem mad, you know, if you've got someone who's been here for 4.5 years and they think they've got half a year to go, are they going to have to wait 5.5 years? Is there going to be, will there be some sort of transitional provisions? At the moment, we just don't know. So I think there are reasons to be very concerned about this. Most important of all, for the people concerned, the people who are going to be hit, the visa holders. It's really stressful having a time-limited visa. You know, if you're you've got a skilled worker visa, you might have a good job with a good employer, but your visa status depends on keeping that job. If you lose your job, you will lose your visa unless you get another job very quickly. It's really stressful. And many people have to pay for their visa applications, which cost thousands and thousands of pounds. So it's to keep someone in that situation for 10 years is a long, long time. For existing visa holders, personally, I think it's just wrong to do that. I think that when people come with an expectation that they're going to get indefinitely to remain after 5 years to then move the goalposts, I don't think they should do that. There's a question about whether it's lawful or not, and there are different views on that. In the past, when changes have been retrospective, sometimes legal challenges have been successful, sometimes not. For businesses, I mean, one possible issue is this going to make the UK a less attractive place? You know, the standard around most countries have a 5-year qualifying period for permanent residence. A couple don't. So apparently Switzerland and Japan, it's 10 years, but it's out of line with other countries. So could this make the UK somewhere that people would be less likely to want to come? Again, it depends on how high that bar is set. And there's very obviously the cost. You know better than anyone how incredibly expensive this whole thing is. The government fees are huge. If you're going to have to sponsor people for 10 years instead of 5, that's a cost for business. Hard to see how that's great for economic growth. I think there's a question about whether the policy will work on its own terms, because what could happen is that it would discourage some people, these great highly skilled people who the government wants, the elite. They think, actually, I don't really want to come to this country if I can't be certain I'm going to get my indefinite leave to remain after 5 years. Whereas perhaps other people will, the people that the government doesn't think are quite so wanted here, they'll stick it out. I mean, I think, say you're a care worker from Zimbabwe on a skilled worker visa, and the prospect, if you leave, you're going back to poverty, you're going to stay. You're going to make sure you stay here for the 10 years, and you're going to stick it out. But say you're an architect, and you've got a good job here, but you think, well, actually, you know, am I going to be able to get, I want to settle down here? And you might think, well, I've got other options. Maybe I'll go to Paris or Dubai instead. So you might end up, the government might end up kicking out the people that it would like to stay, and other people, I don't know. It all depends on the details. If you think this is bad, Reform UK and the Conservatives, Reform UK, their plan is to scrap indefinite leave to remain and remove hundreds of thousands of people. And the Conservatives have said that they put out a draft bill earlier this year, so that if you've got indefinite leave to remain and your salary drops below £38,700, it will be, you'll have your ILR revoked. And the same if you claim any kind of social protection. So you could have someone who's worked here all their life, they've got indefinite leave to remain, they work up to retirement. If they claim a state pension, they will lose their ILR. Those are really, really extreme proposals. This is not so extreme. I think it's the same kind of thing, though, and it's wrapped up in the same kind of language. So I'm really concerned about this. But, so that's my personal view. What matters is what you think, because we're going to be approaching the government, saying, and actually collecting your views and putting forward a case. And what matters is what you think about this. So I would really appreciate some kind of audience participation here. If you wouldn't mind, we're going to see if we can do this. If you wouldn't mind getting out your phones, and we'll do a little a Slido thing to see what you think. The first thing, so you just get the QR code, and then this is a word cloud thing. So you just put in a word. What do you think about this? One word, a couple of words. What do you actually think about this plan? You know what I think about it. Oh, you've not got Wi-Fi. Okay, there's a little, I'm sorry about that. There's a little sort of plastic thing which has got the Wi-Fi code on it. We could pass the password. I'm so sorry about that. Yeah, we should have put that at the start. Okay, man.
No,
okay.
It's going to take a long time. No?
Right, okay, so shocking. Okay, right, pretty strong stuff here. By the way, apparently there is a profanity filter on Slido.
Oh, no.
And but I don't know if I don't know whether the King's
Don't
Inactive is
test it.
taken off. I don't know. No, well, remember it's being recorded as well, so we don't want to, but okay. So we've got a lot of, so unfair. So quite a few people have said unfair. Elitist, yeah. Elitist, interesting, draconian. Against diversity, self-defeating, right. Is anything positive? Anyone going to, can we have that? I don't like, obviously I was leading in a certain direction, but maybe some people think it's good. Perhaps some people think it's necessary to protect the UK economy. Just saying, but no. Okay. I think we've got a pretty good idea of the initial reactions. Let's try another one. So if they do this, if they increase the qualifying period to 10 years, do you think this should apply to existing visa holders? So people are already here on the 5-year route. Should they do that? And you can have, so it's a yes or no, or you can also say don't know or it depends if you're not sure about this. So should it apply to existing visa holders? So we got so far, okay. That's so far, that looks pretty decisive.
Nearly clicked yes.
You nearly clicked yes, yeah. If yes, I don't know if you can take it back once you put it. So okay. Right. Well, there we are. That's we've got quite a few people saying that. 29 people. Okay. And then finally, so now this one is more open. This I honestly don't know the answer to this. If the qualifying period is increased to 10 years, will this make it harder for you, for your business, to attract top talent to work in the UK? Now, I totally accept this might depend on the kind of business you have. You might think, look, we pay oodles of money and people are going to come here anyway, and our people don't really want to stay anyway. So, okay, so interesting. So and this is what I expect. So it depends. So some people say yes. Some people say it depends. Oh, don't know, it depends, creeping up there. Okay, and I think and I totally understand that, because we don't have enough information to know exactly how this is going to work. A lot of people, intuitively, you might think, well, this doesn't sound like the kind of thing that would encourage people to come here, but right, it depends. Great. Okay, thank you so much for that. So look, that's just a snapshot, and I realize you haven't had time to even digest this, think about it. There's going to be a consultation on this. The Home Office will be launching a consultation before the end of the year. You will be able to respond to that consultation directly, but you don't have to, because we will be responding, and what we will do is, when it's launched, we'll contact you and ask for your input. So we'll in a more structured and thoughtful way than this. So you'll be able to tell us what you think, and we'll put all of this together, and we'll respond to that consultation, that Home Office consultation. I don't know when it's going to start. I don't know how long it's going to last. I don't know what they'll think about it. There was a debate in Parliament, and there were a lot of backbenchers, lots of Labour backbenchers, who were very strongly against the proposal. So I think there is room to persuade the government to move on this, and to do it, if they're going to do it in a more sensible way. There is already, the Home Affairs Committee, a parliamentary committee, has got a call for evidence at the moment. So it's rather sort of vague, but they've got a few questions there on this topic itself. We will be responding to that. The deadline is the 2nd of December, and this will help, certainly, just your reactions now will help, but please feel free to talk to us about that, and we'll feed into that. That is not the government's consultation, that's a parliamentary committee, and they're looking at it as well. I don't quite know why they've jumped the gun and doing it before the consultation, but who knows. And just the other thing to bear in mind is that you can always write to your MP. MPs, in my experience, do take notice of what's in their mailbox. They might not have much influence, but perhaps they do. I mean, I did actually write to my MP after the immigration white paper came out. I know my MP a bit, and he kind of guessed what I would think. And I said, look, and I made a point about the retrospective effect. I said, I think this is really wrong. And he did reply and said, I've had lots of people raise this concern. I'm very concerned about it. I'm talking to colleagues in government about this. So it's worth doing that as well. But the main thing is the consultation. So we will, when it comes out, we will email you, and we will ask for your input. And please, please, please do give that to us. So look, that's all we had in our program, but we're very, very happy to answer any questions or hear any comments, anything you've got to say. Please, we've got a little bit of time, 5 minutes, and so please, anything you want to ask at all, or anything you want to say. Anna. Yeah, you should tell us. So you should report. That's okay. That's one of the. So there are various things when you're allowed to, the salary can drop, but you should tell us. And I think that's actually going to be more important than ever now that they're doing with this data sharing and tracking and sharing. So I think that's important. Yeah. So do that. You also do unpaid leave for any reason for 4 weeks in a calendar year as well. But I think that's a really good point. So, and because it seems so obvious that of course someone can go on sick leave, but I think it is going to be more important than ever to tell us about that so that we can report that for you. Yeah. Yes. So good question. Any changes to the spouse route? So there is, so the last government increased the minimum income requirement to £29,000, and it was going to go up even further. And I think that's still under review, isn't it? That's right. Yeah. Any more information on that? So
Not that I'm aware of. I don't think it's going to happen, though.
No,
I think it seems less likely. And the 5-year earned settlement point that we were talking about, that's not talking about spouses of British citizens. Those guys seem to be exempted and will be on a 5-year route as well. So they should be fine, hopefully.
One thing they have done is toughen up the criminality requirements on spouse visas. So that's happened. So it used to be that there was and if people had overstayed and so forth, it wasn't such a problem for a spouse visa, for a spouse of British citizen. But that's changed now. They've made it uniform for all. We don't know how that's going to pan out in practice because there are other legal issues in there. So people might have a human rights claim, but not much is going to. I think that it's no big changes on that. Yes.
That's come from the Home Office. So they said at a conference recently that when they request additional information in respect of a sponsor, they were considering that equivalent to suspension. So if you sort of get interaction with the Home Office, and before they would have suspended your license and then asked for additional information and then revoked potentially, now it seems that they're just asking for additional information and then jumping straight to revocation. And the Home Office were of the opinion that that was procedurally fair. Don't know, but they did say that they had concluded that that was okay. So maybe there's scope to challenge. We'll have to see. But yeah, it's from the Home Office, from the horse's mouth.
Any more? So what we will do, let's wrap up now then. We're going to be here afterwards, so please do stay for a cup of coffee and a chat. We'll be here for another half an hour. We've still got the room, I think we have, for another half an hour, so please do that. Look, thank you all very much indeed for coming. Thanks to the panel, thanks to our marketing team, Levana, thanks to IT and hospitality. Look out for our emails about that consultation. So when it comes out, we'll tell you straight away, and then we'll follow up asking for your input. And obviously, if you have any questions, ask us anytime at all. Thank you all so much. Thanks.